Before we begin, a quick and important disclaimer. The information provided in this video is for educational and entertainment purposes only and does not constitute professional legal, financial, or tax advice. Divorce proceedings in the United States involve complex intersections of state-specific civil laws and religious principles, and the outcomes discussed here are based on historical trends and case studies, rather than a guarantee of future results. Navigating the economic aspects of an Islamic divorce within the American judicial system requires specialized knowledge. We strongly urge every viewer to conduct their own due diligence and consult with the licensed attorney in their jurisdiction, as well as a qualified religious scholar, before making any decisions regarding their marital or financial status. Imagine standing in a civil courtroom in Northern Virginia or Southern California. You have spent the last decade building a life, a career, and a retirement portfolio. You are a Muslim living in the United States, and you are now facing the end of your marriage. You have a nikah contract signed years ago, which stipulates a deferred Mahr, an Islamic dowry, of $50,000. In your mind, that contract represents your final financial obligation. You believe that by paying this amount, you have fulfilled your religious and financial duty. But then the judge speaks. The judge does not just look at your religious contract. They apply the state's principle of equitable distribution or community property. Suddenly, that $50,000 is not the end of the conversation. It is merely a footnote. You are ordered to liquidate half of your 401k, sell the family home to split the equity, and provide monthly spousal support that was never mentioned in your nikah. On the other side of the aisle, a spouse may find themselves in a position where the religious contract they relied on for security is dismissed by a secular judge as being vague or against public policy, leaving them financially vulnerable despite the promises made at the altar. This is the reality of the American Muslim divorce. A high-stakes collision between ancient religious jurisprudence and modern American civil law. For many families, this collision results in a financial catastrophe that could have been mitigated with the right knowledge. According to data from the Institute for Social Policy and Understanding, the divorce rate within the American Muslim community has trended toward mirroring the broader U.S. population, yet the economic literacy regarding how these two legal systems interact remains dangerously low. We are entering a deep dive masterclass into the economic architecture of divorce for Muslims in the USA. This is not about the theology of ending a marriage. It is about the dollars, the cents, the assets, and the legal precedents that will determine your financial survival. Over the course of this series, we will bridge the gap between Sharia principles and U.S. civil court reality. We will solve the problem of the double liability trap, where individuals find themselves paying both Islamic financial obligations and civil court mandates without credit for either. We will provide a roadmap for understanding how to structure your assets today to ensure that your religious values are respected without falling afoul of state laws that can override your private agreements. To understand the economic landscape, we must first dissect the primary financial instrument of the Islamic marriage, the Mahr. In the United States, the Mahr is often misunderstood by both the parties involved and the judges presiding over their cases. Historically, U.S. courts have struggled with how to categorize this payment. Is it a gift? Is it a prenuptial agreement? Or is it a simple contract for services? The answer varies wildly depending on which state you are in. For example, look at the case study of a landmark New Jersey ruling where the court treated the Mahr as a valid and enforceable contract under the neutral principles of law approach. This means the court ignored the religious undertones and treated the nikah as a standard business agreement. However, for this to happen, the contract had to meet specific criteria. It had to be in writing, signed voluntarily, and the terms had to be clear. If your Mahr is written on a napkin or a generic mosque certificate with no specific dollar amount or payment schedule, a U.S. judge is likely to throw it out entirely, leaving you at the mercy of the state's default divorce laws. The economic implications of prompt versus deferred Mahr in a U.S. context are staggering. In many traditional settings, a large portion of the Mahr is deferred, meant to be paid only in the event of death or divorce. In the American economy, this creates a significant unsecured debt that most men do not account for on their balance sheets. When a divorce filing occurs, that deferred Mahr becomes due immediately. Simultaneously, the U.S. court may be looking at equitable distribution. Let's look at the numbers. If a couple has $200,000 in marital assets and a deferred Mahr of $50,000, the husband might assume he gives $50,000 and keeps $150,000. Instead, the court might split the $200,000 down the middle, $100,000 each. And then in a separate motion, the wife's counsel may sue for the $50,000 mahr as a separate contractual debt. This results in the husband leaving the marriage with only $50,000, while the wife leaves with $150,000. This stacking of liabilities is one of the most common financial shocks for Muslim men in the U.S. legal system. Furthermore, we must address the concept of marital property versus separate property. Under Islamic law, the wealth a woman earns or inherits during the marriage is generally considered her separate property, while the husband is traditionally responsible for all household expenses. However, in the U.S., almost everything earned by either spouse during the marriage is considered marital property. This creates a massive economic disconnect. If a Muslim wife has been saving her salary in a private account while the husband pays the mortgage and bills, she may believe that money is religiously hers alone. Yet, in a U.S. divorce court, that account is 50% his. Conversely, if a husband has been putting money into a business, he may believe it is his sole enterprise, but the court will see the sweat equity and financial contribution of the household as a reason to grant the wife a significant share of that business's valuation. The complexity deepens when we consider the social cost and the role of the community. In the U.S., many couples attempt to resolve their economic disputes through an imam or a local shura council before or during civil litigation. While this can sometimes lead to an amicable settlement, it also carries the risk of legal limbo. We have seen case studies where a husband grants a religious divorce, talaq, and pays a settlement through a mosque, only for the wife to later file in civil court for a larger sum, arguing that the religious settlement was signed under duress or lacked full financial disclosure. Without a civil release of claims, the husband is essentially paying twice. This masterclass is designed to prevent these outcomes. We will investigate the historical trends of how courts in states like New York, Texas, and Michigan handle these disputes. We will look at the specific language required in a nikah to make it stand up in a U.S. court of law. We will examine the tax implications of mahr payments, whether they can be categorized as alimony, which has changed significantly under the Tax Cuts and Jobs Act, or if they are viewed as non-taxable transfers of property. The promise of this deep dive is clarity. By the end of this part, you will understand why your religious financial planning cannot exist in a vacuum. You will see that in the United States, the only way to protect your religious principles is to wrap them in the ironclad protection of civil contract law. We are moving beyond the surface-level advice and into the granular details of asset protection, contractual validity, and the economic reality of being a Muslim in the American legal system. We are solving the problem of financial ambiguity that has ruined the credit, the savings, and the futures of countless families. Prepare yourself because we are going deep into the numbers that your local community board likely never discussed. This is the economic survival guide for the modern American Muslim. To understand the economic reality of an Islamic divorce in the United States in 2026, we have to look at the primary financial pillar of the marriage contract, the mahr. While many in the community view the mahr as a spiritual bond or a symbolic gesture of protection, the American legal system views it through a much colder lens. In the eyes of a secular judge in a state like New Jersey or Michigan, your nikah is not just a religious ceremony. It is potentially a binding civil contract. But there is a massive catch that has left thousands of individuals financially decimated. Imagine a scenario involving a couple we will call Omar and Sarah, living in a high-cost area like Northern Virginia in early 2026. When they married 10 years ago, they signed a nikah contract that specified a mahr of $75,000, with $5,000 paid up front and $70,000 deferred. At the time, $70,000 felt like a distant theoretical number. Fast forward to today and they are filing for divorce. Omar assumes that because they are in the United States, the $70,000 mahr is a religious matter that the secular courts will ignore. He believes the court will simply look at their joint assets, a house with $400,000 in equity and $200,000 in various retirement accounts, and split them down the middle. However, Sarah's legal team presents the nikah contract to the judge as a valid prenuptial agreement. In the state of Virginia, as in many other jurisdictions, courts utilize what is known as the neutral principles of law approach. This means the judge will strip away the religious terminology. They will not look at it as an Islamic dowry. They will look at it as a contract where one party agreed to pay another party a specific sum of money upon a specific triggering event, in this case, the dissolution of the marriage. If the contract was signed voluntarily and the terms are clear, the judge may rule that the $70,000 is a debt that Omar owes Sarah in addition to her 50% share of the marital assets. This is where the math becomes brutal. If the total marital pot is $600,000, each spouse is typically entitled to $300,000. But if the judge enforces the mahr as a separate contractual obligation, Omar must pay that $70,000 out of his $300,000 share. He walks away with $230,000, while Sarah walks away with $370,000. This historical trend of stacking religious obligations on top of civil distributions is a potential outcome that many American Muslims fail to plan for, leading to a significant loss of individual net worth during the most vulnerable transition of their lives. But the situation can also flip into a different kind of financial disaster. Consider the case study of a couple in a community property state like California. Imagine a husband named Yusuf who has spent the last 15 years building a successful tech consultancy. His wife, Amina, stayed home to raise their 3 children. Their nikah specified a mahr of only $5,000. Yusuf believes that by paying this $5,000, he has fulfilled his financial obligation to Amina, according to his understanding of religious law. He expects to keep his business and his high-value investment portfolio intact. In this scenario, the U.S. legal system can deliver a massive shock to Yusuf's expectations. California courts generally prioritize the principle of community property over private religious agreements, unless those agreements meet extremely strict statutory requirements for a prenuptial contract. Because the nikah was not drafted by U.S. licensed attorneys and did not include a full disclosure of assets at the time of signing, the judge likely dismisses the mahr agreement as non-binding in the civil sphere. Instead of paying $5,000, Yusuf is ordered to give Amina 50% of the valuation of his business and half of every dollar earned during the marriage. For Yusuf, the economic aspect of his divorce is not defined by his religious contract, but by the state's mandate to ensure that the lower-earning spouse is not left destitute. Step by step, we must analyze why some mahr agreements stand up in court while others crumble. The first factor is the statute of frauds. In most U.S. states, any agreement made in consideration of marriage must be in writing and signed by the party to be charged. If your mahr was an oral promise made in front of witnesses at a dinner party, it holds zero weight in a 2026 U.S. courtroom. The second factor is the concept of unconscionability. If a mahr is so large that it would leave the payer in a state of absolute poverty, or so small that it shocks the conscience of the court given the couple's lifestyle, a judge may choose to set it aside. Let's look at the historical trends involving the case of Odatala versus Odatala, a landmark New Jersey case. The court decided to enforce the mahr because the couple had filmed the signing of the nikah, showing that it was a clear, voluntary agreement with a specific dollar amount. The court treated it like a simple contract for the payment of money. This set a precedent that if you want your religious financial obligations to be recognized, they must be documented with the same rigor as a corporate merger. However, there is a dangerous middle ground known as the vagueness doctrine. If your nikah says the mahr is 30 pieces of gold or a certain amount of property back in another country, you are entering a legal minefield. In 2026, U.S. judges are increasingly hesitant to value foreign assets or non-liquid commodities. If the court cannot determine the exact U.S. dollar value of the mahr, without getting bogged down in religious interpretation or foreign law, they will likely declare the provision void for vagueness. This leaves the parties with no contractual protection and forces them into the default state laws, which may be the exact opposite of what they intended when they stood at the altar. Another critical economic aspect is the timing of the payment. Under U.S. law, if a mahr is paid during the marriage, it is often categorized as a gift. If you give your spouse $50,000 in 2024 as part of your mahr obligation, and then divorce in 2026, you cannot necessarily claim that as a credit toward your divorce settlement. The court may view that as marital funds used for a marital purpose, and you might still be ordered to pay an additional settlement during the divorce proceedings. This is the double payment trap that occurs when individuals do not have a clear accounting of which funds are separate and which are marital. To navigate this, one must understand the step-by-step process of asset characterization. Before a single dollar is moved, the court identifies every asset owned by both parties. They then categorize them as separate property, which was owned before the marriage, or marital property, which was acquired during the marriage. The mahr often sits in a gray area. Is it a premarital debt? Is it a postmarital gift? Without a specific legal rider attached to the nikah, you are essentially leaving your entire financial future to the discretion of a judge who may have never seen a nikah contract before. We are seeing a shift in 2026 where savvy couples are beginning to use Islamic marriage contracts as a starting point, but then reinforcing them with a secondary document known as a postnuptial agreement. This document translates the religious intent into the specific legal language required by their home state. This prevents the scenario where a spouse is surprised by a six-figure liability or a sudden loss of property rights that they thought were protected by religious tradition. The economic stakes are not just about the immediate cash payout of the Mahr. They extend into the realm of spousal support and retirement accounts. In some interpretations of Islamic law, alimony is limited to a 3-month waiting period known as Iddah. However, in the U.S., spousal support can last for years or even a lifetime depending on the length of the marriage. If you rely solely on your religious understanding and fail to account for the civil court's power to mandate long-term support, your post-divorce budget will be fundamentally broken. As we peel back the layers of this financial complexity, we have to ask, what happens when the assets aren't just cash and houses? What happens when we enter the world of complex investments, business valuations, and the hidden costs of international assets? The collision between the U.S. tax code and Islamic financial obligations creates a whole new set of problems that can lead to massive IRS penalties if handled incorrectly. The question remains, how do you prevent the government from taking a massive cut of your settlement? And what happens when the court orders you to do something that your faith expressly forbids? In the next part, we are going to dive into the nightmare of tax liabilities and the hidden divorce taxes that most people don't see coming until their bank accounts are frozen. We will explore how to protect your business interests from being liquidated by a court order that doesn't care about your religious exemptions. When the gavel falls in a U.S. divorce court in 2026, the Internal Revenue Service is often the invisible third party sitting at the table, and they almost always get their cut before either spouse. One of the most dangerous economic misconceptions in the American Muslim community is that a religious settlement is a private matter that exists outside the reach of federal tax law. This is a mistake that can lead to potential outcomes where a significant portion of your hard-earned wealth is vaporized by taxes and penalties that could have been avoided with proper forensic planning. Consider the economic reality of a property transfer. Under Internal Revenue Code Section 1041, transfers of property between spouses or former spouses incident to a divorce are generally non-taxable. However, the definition of incident to a divorce is strictly time-bound. If you are paying out a deferred Mahr 3 or 4 years after the civil decree because you were waiting for assets to liquefy, you may no longer be protected by Section 1041. Suddenly, that transfer is viewed as a taxable sale or a gift, potentially triggering capital gains taxes or eating into your lifetime gift tax exclusion. Imagine a case study involving a couple in Chicago. Let us call them Robert and Miriam. They are divorcing in 2026 after 20 years of marriage. Their primary asset is a portfolio of rental properties currently valued at $2 million. As part of their Islamic settlement, Robert agrees to transfer 2 of these properties to Miriam to satisfy her Mahr and her share of the marital estate. Robert thinks he is giving her $500,000 in equity, but because these properties were purchased years ago at a low-cost basis, there is a massive embedded tax liability. When Miriam goes to sell those properties a year later to fund her new life, she is hit with a capital gains tax bill that reduces her actual net recovery by 20%. Robert walked away with clean assets, while Miriam was left holding the tax bill for the appreciation that happened while they were married. In the American legal system, the person who receives the asset usually receives the tax basis along with it. If your divorce agreement does not explicitly account for these hidden tax costs, the economic split is never truly 50-50. This leads us to the nightmare of business valuations and the risk of forced liquidation. Imagine a character named David who owns a specialized medical laboratory in Texas. In 2026, his business is thriving, but his marriage is ending. His wife, Yasmin, has a claim to the value of that business under the state's community property laws. The court appoints a forensic accountant to perform a business valuation. In historical trends, there are 3 main ways this is done: the asset-based approach, the market approach, and the income approach. The forensic accountant looks at David's books and determines that while the physical equipment is only worth $200,000, the goodwill and the future income stream of the lab make the business worth $3 million. David does not have $1.5 million in cash to buy out Yasmin's share. He is faced with a potential outcome where the court orders him to take out a high-interest business loan or, in extreme cases, to sell the business entirely to satisfy the divorce judgment. The economic aspect of his divorce just transformed from a domestic dispute into the destruction of his professional legacy. To make matters worse, David may be a victim of what is known as double dipping. This happens when the court treats the business's income as an asset to be divided, and then uses that same income a second time to calculate how much spousal support David must pay. This can lead to a situation where David's post-divorce cash flow is insufficient to even keep the business operational. Now, let us talk about the retirement trap. For many professional Muslims in the U.S., their 401k or IRA is their largest liquid asset. If a judge orders you to pay $100,000 Mahr immediately, and you do not have the cash, you might look at your retirement account as a quick fix. If you simply withdraw that money in 2026, you are making a catastrophic economic move. You will immediately owe ordinary income tax on the withdrawal, which could be as high as 37% depending on your bracket, plus a 10% early withdrawal penalty if you are under age 59 and a half. The correct step-by-step procedure involves a Qualified Domestic Relations Order, or QDRO. This is a specific legal instruction that allows the tax-free transfer of retirement funds from one spouse's account to the other's. However, many people forget that once the money is in the other spouse's account, it is still subject to taxes when they eventually withdraw it. If Sarah receives $200,000 via QDRO and John keeps $200,000 in cash, Sarah has actually received significantly less value because her money is pre-tax while his is post-tax. In 2026, ignoring the tax-adjusted value of assets is the fastest way to lose your shirt in a divorce settlement. We must also address the complexity of international assets, which is a common factor for many families in the U.S. community. Imagine a husband named Omar who owns a high-end apartment in Dubai and land in Istanbul. During the divorce in a California court, Omar argues that the court has no jurisdiction over foreign land. He is technically correct. A U.S. judge cannot sign an order that forces the Dubai Land Registry to change a title. However, the U.S. court has in personam jurisdiction over Omar. This means the judge can look at the total value of Omar's global wealth and say, since you are keeping the $1 million apartment in Dubai, I am going to give your wife the entire 3-bedroom house here in the United States to balance the scales. If Omar cannot prove the exact value of the foreign property through a certified, English-translated appraisal that meets U.S. court standards, the judge may rely on Yasmin's estimate, which could be wildly inflated. The economic risk here is that you end up losing all your liquid, accessible U.S. assets in exchange for keeping foreign assets that may be difficult to sell, subject to foreign currency fluctuations, or located in a country with unstable property laws. Then there is the issue of legal fees, which act as a massive tax on the marital estate itself. In 2026, high-conflict divorces involving business valuations and international assets can easily see legal and expert fees exceeding $100,000 per side. These fees are generally not tax-deductible. This is money that is simply gone from the family's net worth. We have seen case studies where couples spent $300,000 fighting over a $400,000 house, leaving both parties with virtually nothing. The economic aspect of the divorce becomes a race to the bottom where the only winners are the professionals involved. As we look at the financial landscape, we have to realize that the Mahr, the alimony, the child support, and the property division are all interconnected gears in a single machine. If you move one, the others all shift. But there is one gear that is more unpredictable than all the others, and that is the calculation of future support. Many people assume they know what their obligations will be based on their current salary, but in the volatile economy of 2026, the court's power to base support on earning capacity rather than actual earnings can lead to a lifetime of debt. What happens when a court decides you should be making more money than you are, and sets your payments based on a fantasy version of your career? And how do the hidden costs of child-related expenses, those that go beyond simple child support checks, end up being the biggest financial drain of all? In the next part, we are going to break down the brutal math of the earning capacity trap and the specific economic strategies used to protect your future income from being garnished for decades. We will also reveal why the way you handle your 2026 tax return during the divorce can either save you a fortune or put you in the crosshairs of an audit. One of the most devastating financial surprises in the American legal system is the concept of earning capacity. Many individuals entering a divorce in 2026 believe that their current bank statement, or their most recent pay stub, is the final word on how much they will have to pay in support. They assume that if they are making less money now than they were 2 years ago, their alimony and child support obligations will naturally reflect that lower number. However, U.S. courts operate on a principle that can feel like a financial trap. They do not just look at what you are making, they look at what you should be making. This is known as the imputation of income, and it is a cornerstone of the economic aspect of divorce that can lead to potential outcomes where a person is left with almost zero disposable income. Imagine a scenario involving a character named Michael, a senior software engineer living in the high-growth tech corridor of Austin, Texas, in 2026. For the last decade, Michael has consistently earned $280,000 a year. As his marriage begins to dissolve, Michael feels a deep sense of burnout and resentment. He decides that this is the perfect time to take a sabbatical. He quits his high-pressure corporate job and takes a part-time position at a local nonprofit, earning only $60,000. Michael believes that by the time he reaches the final hearing, the judge will calculate his child support and spousal maintenance based on this new $60,000 salary. Michael's strategy is a common historical trend that often backfires. In a deep-dive masterclass of divorce economics, we have to look at the step-by-step process a judge uses to impute income. First, the court will appoint or allow the other spouse to hire a vocational expert. This expert will perform a comprehensive analysis of Michael's resume, his professional certifications, and his past earnings. They will then look at the 2026 job market in Austin and prove to the court that Michael is voluntarily underemployed. If the expert shows that there are dozens of open positions for senior software engineers that Michael is qualified for, the judge will ignore his actual $60,000 income. Instead, the judge will impute him at his former salary of $280,000. Michael is then ordered to pay support as if he were still making that high salary. Because these payments are often automatically deducted or carry severe legal penalties if unpaid, Michael finds himself in a position where his entire $60,000 salary is consumed by support payments, leaving him with nothing for his own rent or food. This potential outcome highlights why any career change during a divorce must be documented with extreme care. If the move to a lower-paying job is not for the purpose of avoiding support, but rather due to a genuine layoff, a medical condition, or a shifting industry in 2026, the burden of proof is on Michael to provide medical records, rejection letters from job applications, or data showing that his specific sector of the tech industry has contracted. Without this evidence, the court assumes the worst, and the economic fallout is catastrophic. Parallel to the earning capacity trap is the minefield of the 2026 tax return. For many families, the way they file their taxes during the year of their divorce can mean a difference of tens of thousands of dollars. Historically, many couples have used the married filing jointly status to capture the largest possible standard deduction and favorable tax brackets. However, in the middle of a divorce, signing a joint tax return is a massive economic risk. When you sign a joint return in 2026, you are accepting joint and several liability. This means the IRS can come after either spouse for the full amount of any unpaid taxes, interest, or penalties, regardless of who earned the money or who claimed the deduction. Imagine a case study involving a small business owner named Kevin and his spouse, Julia. Kevin has been aggressive with his business expenses in 2026, deducting things that might be considered personal under an audit. He asks Julia to sign a joint return so they can save $8,000 in total taxes. Julia, wanting to be cooperative, signs the document. 2 years later, the IRS audits that 2026 return and finds $40,000 in disallowed deductions, resulting in a $60,000 bill with interest. Even though they are now divorced and Julia had nothing to do with the business, the IRS can legally seize Julia's bank accounts or garnish her wages to pay Kevin's business tax debt. In 2026, savvy individuals often insist on filing married filings separately, even if it costs more in the short term, to insulate their post-divorce wealth from their ex-spouse's potential tax liabilities. We must also break down the math of the child tax credit and the dependency exemptions. In 2026, these are not just paperwork formalities, they are liquid assets. For a family with 3 children, the right to claim those children as dependents can represent a significant annual cash flow advantage. The default rule is that the custodial parent, the one who has the children for more than half the year, gets the credit. However, in high-stakes negotiations, this right is often traded. A non-custodial parent might agree to take on a larger share of the marital debt, or pay a higher Mahr in exchange for a court order that allows them to claim the children on their taxes every other year. This is a step-by-step negotiation where you must calculate the actual dollar value of the tax credit based on your specific 2026 tax bracket before agreeing to a trade. Beyond the base support and taxes, there are the hidden add-on expenses that many traditional Islamic marriage contracts do not anticipate. In the U.S., child support guidelines generally cover basic food, clothing, and shelter. But in 2026, the lifestyle of an American family often includes significant additional costs. Courts frequently order a pro rata split of expenses such as private school tuition, high-level competitive sports, and specialized healthcare not covered by insurance. Imagine if the children are enrolled in an elite gymnastics program and private Islamic school, costing a combined $2,000 a month. If the court orders a 60-40 split based on the parents' respective incomes, the parent paying support might find themselves on the hook for an extra $1,200 a month on top of their base child support check. Furthermore, there is the issue of life insurance as security. U.S. judges almost always require the paying spouse to maintain a life insurance policy with enough coverage to pay out the total remaining support obligations if the payer were to pass away. In 2026, for a young father with 15 years of support ahead of him, this could mean maintaining a $2 million term life policy. The premiums for this policy are an often overlooked economic drain that can significantly impact the payer's monthly budget. As we look at these layers of financial obligation, from imputed income to tax liabilities and hidden add-on costs, a clear picture emerges. The economic aspect of a U.S. divorce is an exercise in long-term liability management. You are not just splitting the assets you have today. You are partitioning your future labor and your future tax identity. The legal system in 2026 is designed to ensure that the financial status quo of the children and the lower-earning spouse is maintained, often at a high cost to the primary earner's future wealth-building potential. But what happens when the assets aren't just in a bank account or a paycheck? In the modern era, wealth is increasingly tied up in digital spaces. What happens to the YouTube channel revenue, the Bitcoin wallet, or the airline miles accrued over a 20-year marriage? How do forensic accountants in 2026 trace money that has been moved through decentralized finance platforms or hidden in overseas accounts? In the next part, we are going into the high-tech world of digital asset tracing. We will explore how to uncover hidden wealth in the blockchain and why your social media handles might be worth more in your divorce settlement than your car. We will also reveal the specific economic dangers of Social Security credits and why the length of your marriage, down to the very day, could determine whether you receive a federal check for the rest of your life. The shift toward a digital-first economy in 2026 has fundamentally altered the forensic landscape of divorce. Gone are the days when a forensic accountant simply looked at paper bank statements and canceled checks. Today, the economic battlefield includes decentralized finance, non-fungible tokens, and private keys. In the context of an Islamic divorce in the USA, where financial transparency is a religious mandate, but often a legal hurdle, the discovery of digital assets has become a high-stakes game of cat and mouse. Imagine a case study involving a character named Jason, a cybersecurity consultant in San Jose. Over the last 8 years of his marriage to Layla, Jason systematically moved a portion of his high six-figure salary into various cryptocurrency wallets. He utilized privacy coins and decentralized exchanges to obfuscate the trail. When the divorce proceedings began in early 2026, Jason's disclosed financial affidavit showed only a standard savings account and a modest 401k. He claimed that his aggressive tech investments during the 2022 market downturn had all gone to zero. However, in 2026, forensic accountants utilize advanced on-chain analytics. The step-by-step process of uncovering these assets begins with a deep dive into bank and credit card metadata. By tracing small, recurring transfers to gateways like Coinbase or Kraken, investigators can establish a timeline of when funds entered the crypto ecosystem. From there, they subpoena exchange records to find the public wallet addresses associated with the account. Even if Jason moved the assets to a hardware wallet, the permanent nature of the blockchain allows an expert to track the movement of those specific units of currency. If the court finds that Jason intentionally hid these marital assets, the potential outcomes are severe. In many U.S. jurisdictions, a judge may award 100% of the hidden asset to the other spouse as a penalty for fraud on the court. The economic lesson here is that in the age of transparent ledgers, the cost of concealment often far outweighs the value of the asset itself. Beyond currency, we must address the valuation of digital intellectual property, such as social media platforms. Imagine if Layla, during the marriage, built a successful lifestyle YouTube channel or a TikTok presence with 2 million followers. In 2026, a social media handle is not just a hobby, it is a revenue-generating business asset. If the channel produces $30,000 a month in ad revenue, sponsorships, and affiliate marketing, the U.S. court views this as marital property if it was developed during the marriage. The valuation process for a digital brand is complex. A forensic expert looks at the historical trends of the channel's earnings, the engagement rate of the audience, and the projected longevity of the niche. They might use a discounted cash flow analysis to determine the present value of that future income stream. If the channel is valued at $1 million, and Jason can prove he contributed to the strategy, filming, or editing, even in an informal capacity, he may be entitled to a significant portion of that valuation. This creates a unique economic tension in Islamic divorces. How do you divide a digital persona? Often, the court will not order the channel to be sold, as that would destroy its value. Instead, they might order a distributive award, where the person keeping the channel must pay the other spouse their share in cash or other assets, like the equity in the family home. We then move from the digital realm to the federal level, specifically the critical economic role of Social Security credits. For many American Muslims, especially those in traditional domestic roles, Social Security derivative benefits are the most significant piece of their long-term retirement security. However, these benefits are governed by a strict federal rule known as the 10-year cliff. Under U.S. law, if your marriage lasts at least 10 years, you are eligible to receive Social Security benefits based on your ex-spouse's earnings record once you reach retirement age, provided you remain unmarried. These benefits do not reduce the amount the primary earner receives, but they provide a vital safety net for the lower-earning spouse. Imagine a scenario where a couple is at 9 years and 10 months of marriage. If the divorce is finalized today, the lower-earning spouse loses 100% of their right to claim benefits based on the other's record, a loss that could total hundreds of thousands of dollars over a lifetime. In 2026, a strategic divorce attorney will often advise their client to delay the final decree by a few months to cross that 10-year threshold. This is a purely economic move that requires no cooperation from the other spouse, yet it secures a federal entitlement that can be the difference between poverty and stability in old age. The length of the marriage also dictates the duration and amount of spousal support, often referred to as alimony. In historical trends across states like New York and Florida, marriages are categorized into tiers: short-term, typically under 7 years, moderate-term, 7 to 15 or 17 years, and long-term, over 17 or 20 years. The closer you get to a long-term designation, the more likely a court is to award permanent or indefinite alimony. Let us look at the step-by-step math of an alimony calculation in 2026. A judge might use a formula that takes 30% of the higher earner's gross income and subtracts 20% of the lower earner's gross income, with a cap to ensure the recipient does not end up with more than 40% of the combined income. If a husband earns $500,000 and the wife earns zero, the starting point for negotiation could be $150,000 a year in support. If the marriage is categorized as long-term, this obligation could last until the husband retires or until the wife remarries. This represents a multi-million-dollar transfer of future wealth that is entirely separate from the division of current assets or the payment of the Mahr. Furthermore, we must account for the economic impact of healthcare. In the U.S., many spouses are covered under their partner's employer-sponsored health insurance. The moment the divorce decree is signed, that coverage typically ends. In 2026, the cost of an individual gold-tier health insurance plan can exceed $15,000 a year. If one spouse has a chronic medical condition, the loss of insurance is an immediate and massive economic blow. This often leads to negotiations for COBRA coverage, where the higher earner is required to pay the premiums for up to 36 months to allow the other spouse to transition. Every day spent in a marriage has an economic value. The day you marry, you begin accruing rights to your spouse's pension, their 401k, their Social Security, and their future income. The day you divorce, those accruals stop. The specific date of separation, the moment the court decides the joint economic enterprise ended, is one of the most litigated points in a 2026 divorce. Was it the day one spouse moved out? Was it the day the petition was filed? Or was it months earlier when they stopped sleeping in the same room? The difference of 6 months in a separation date can mean the difference of tens of thousands of dollars in shared stock options or retirement contributions. As we conclude this part of the masterclass, a daunting reality becomes clear. The U.S. legal system view of a marriage is that of a full financial partnership where every digital coin, every social media click, and every federal credit is on the table. But what happens when the assets are locked in a way the court cannot easily reach? What happens when a spouse uses a religious reason to refuse to cooperate with a court-ordered financial split? And how do you handle the specific economic nightmare of a frozen professional license or a degree that was earned while the other spouse worked to put you through school? In the next part, we are going to dive into the controversial world of professional degrees as marital property. We will look at the enhanced earning capacity doctrine and why your medical or legal license might be the most expensive thing you ever own. We will also explore the psychological and economic warfare of the get, the religious divorce, and how it is sometimes used as a bargaining chip to extort better financial terms in a civil settlement. We will uncover the specific strategies to neutralize this leverage and ensure that your religious freedom is not sold for a civil settlement. The intersection of professional achievement and marital dissolution creates one of the most complex economic puzzles in the American legal system of 2026. For many Muslim families in the United States, the marriage period is often a time of intense upward mobility where one spouse may work multiple jobs or manage the household specifically to allow the other to pursue a high-value professional degree or license. In the eyes of a divorce court, that medical degree, law license, or specialized certification is not just a personal achievement. It is an economic asset often referred to as enhanced earning capacity. Imagine a case study involving a couple named David and Sarah living in New York. Throughout their 12-year marriage, David worked as a teacher while Sarah attended medical school and completed a grueling residency in neurosurgery. In 2026, just as Sarah begins her career as a high-earning specialist with a projected annual income of $600,000, the marriage ends. Under historical trends in certain jurisdictions, David's legal team might argue that Sarah's medical license is marital property. Even though New York specifically amended its statutes to move away from the direct valuation of licenses as property, the underlying principle of reimbursement remains a powerful force in 2026. The court may look at the enhanced earning capacity Sarah now possesses because of the joint efforts of the couple during the marriage. To calculate the value of this asset, a forensic economist follows a rigorous step-by-step process. First, they determine the present value of the lifetime earnings Sarah would have expected to make with just her undergraduate degree. Then, they project her lifetime earnings as a neurosurgeon. The difference between these two numbers, often totaling several $1,000,000, is the enhanced earning capacity. While the court may not give David half of the degree itself, it may award him a larger share of the other marital assets, such as the equity in their home or a significant chunk of Sarah's retirement accounts, to balance the scales. This is often referred to as reimbursement alimony or a distributive award. For the spouse who earned the degree, the potential outcome is a massive financial lien against their future labor, essentially a tax they must pay to their former spouse for years to come. This economic reality often crashes directly into the religious framework of the divorce. We must address the high-stakes leverage involving the religious divorce, known as the talaq or the khula. In 2026, we are seeing a trend where the civil and religious processes are used as weapons in a game of financial chicken. Imagine if David, knowing he faces a massive civil settlement, refuses to grant Sarah a religious divorce unless she agrees to waive her right to her share of the assets or forfeits her Mahr. This is a form of economic coercion that has historically been used to extort better financial terms in the civil arena. However, the legal landscape in the United States is evolving to combat this. In states like New Jersey and New York, judges have grown increasingly weary of what they call get statutes or similar legislative principles intended to prevent one spouse from using a religious barrier to hold the other captive. If Sarah can prove that David is withholding a religious divorce solely to gain an advantage in the distribution of their 401k or the valuation of the house, a U.S. judge may find this to be unconscionable conduct. In some case studies, courts have gone as far as to increase the amount of spousal support the husband must pay for every month he refuses to remove the religious barrier to his wife's remarriage. This effectively turns the religious leverage into a mounting financial liability for the person attempting to use it. Conversely, the wife may find herself in a position where she must pursue a khula, a divorce initiated by the woman, which traditionally involves the return of the Mahr. In a 2026 U.S. courtroom, this creates a fascinating economic conflict. If Sarah signs a document in a religious setting saying she waives her Mahr to get her freedom, does that waiver carry over to her civil rights? Historically, U.S. courts have been split. If the waiver was signed under duress, or without the advice of an independent civil attorney, the court may declare the waiver void. This means Sarah could potentially get her religious freedom through the khula and still successfully sue for her full share of the marital property and spousal support in the civil court. This double recovery, or split outcome scenario is a major point of contention in modern litigation. The economic aspect of professional degrees also extends to the concept of the trailing spouse. Imagine a character named Marcus who moved 3 times across different states to support his wife's corporate climb. Each move reset Marcus's own career clock, preventing him from reaching senior management levels. In 2026, the court looks at the opportunity cost Marcus incurred. The valuation is not just about what Sarah earned, but about what Marcus lost. This is calculated by comparing Marcus's actual 2026 earnings to a but-for scenario where he had stayed in one company and progressed normally. The difference becomes part of the negotiation for the term and duration of alimony. We must also analyze the impact of the 2026 economy on lifestyle maintenance support. When a couple has achieved a high level of professional success, the court's goal is often to ensure both parties can maintain a standard of living reasonably comparable to that enjoyed during the marriage. If the couple lived in a $5 million home and traveled extensively, the lower-earning spouse's support requirements are not based on basic needs, but on the continuation of that luxury. For the high earner, this means the economic cost of the divorce is not a one-time payment, but a permanent alteration of their lifestyle. They may find themselves working until 75 just to cover the support payments mandated by a lifestyle they no longer share. The role of transitional alimony is another step-by-step factor. This is specifically designed for cases where one spouse needs to return to school or gain new certifications to become self-sufficient post-divorce. In 2026, with the rapid displacement of jobs by AI and automation, the cost of this retooling is higher than ever. A court may order the higher-earning spouse to pay for a 2-year master's degree and all living expenses for the other spouse as part of the divorce settlement. This is an upfront economic investment that the court views as a way to eventually end the need for long-term support. Every professional decision made during a marriage, taking a promotion, moving for a job, or choosing to stay home, is an entry on an invisible economic ledger. When the divorce begins in 2026, that ledger is audited with forensic precision. The degrees on the wall are not just symbols of pride. They are future cash flows that must be divided. The religious contracts are not just spiritual documents. They are potential evidence of coercion or contractual intent. As we move forward, we must look at the most sensitive economic aspect of all: the children. Beyond the monthly support checks, how does the American legal system handle the massive costs of university tuition, long-term health care, and the inheritance rights that many parents assume are protected by Islamic law? What happens when a civil judge's order on college savings accounts contradicts your religious views on interest and debt? In the next part, we are going to break down the education fund trap. We will look at how 529 plans and college contribution orders can drain your retirement fund before you even stop working. We will explore the add-on expenses that can double your child support overnight, and why the age of majority, in your specific state, might be the most important number in your entire financial plan. We will also reveal how the 2026 inflation rates are forcing courts to build cost-of-living escalators into every divorce decree, making your payments increase, even if your salary doesn't. The financial architecture of a family does not simply dissolve when the parents part ways. Instead, it enters a period of intense state-mandated restructuring that can last for decades. In the United States in 2026, the economic burden of raising children post-divorce has reached an all-time high, driven by the explosive costs of specialized education, competitive extracurriculars, and a healthcare system that continues to outpace standard inflation. For the American Muslim family, this restructuring often reveals a massive gap between the traditional expectations of child support and the cold, calculated reality of a U.S. civil court order. We must begin by deconstructing the education fund trap, which has become a primary point of financial contention in modern divorces. Imagine a character named Ryan, a professional in New Jersey, and his wife Fatima. Over 15 years of marriage, they diligently contributed to a 529 college savings plan for their 2 children, which in 2026 holds nearly $150,000. In many U.S. jurisdictions, these funds are not legally the property of the children. They are marital assets owned by the parents. During the property division phase, the court must decide who controls this account. If Ryan is named the successor owner, Fatima may demand an offsetting credit from the house equity or retirement accounts to account for her half of that $150,000. Conversely, if the court orders the funds to remain strictly for education, it effectively locks away a massive portion of the couple's liquid net worth, preventing either parent from using those funds for their own post-divorce housing needs. However, the trap goes deeper. In states like New Jersey, New York, and Massachusetts, Courts have the statutory authority to order parents to contribute to the cost of higher education, even after the child has reached the age of 18. This is a potential outcome that many fathers, in particular, do not anticipate. Imagine if Ryan's daughter is accepted into a prestigious university where the 2026 tuition, room, and board total $90,000 per year. Even if the 529 plan is exhausted, the court can perform a step-by-step analysis of Ryan's current income and Fatima's earning capacity and order them to pay the remaining balance. This obligation can persist until the child is 23 years old or graduates with an undergraduate degree. In the American legal system, your child support check is often just the baseline. The college contribution order is the financial tidal wave that can wipe out a decade of retirement savings. This brings us to the critical economic distinction between the age of majority and legal emancipation. Historical trends show that while many parents assume their financial obligation ends when a child turns 18, the reality varies wildly by state. In a state like Florida, child support generally terminates on the child's 18th birthday or upon high school graduation. However, in New York, the age of support is 21. This 3-year difference represents a massive economic shift. If the monthly support is $3,000, a parent in New York will pay $108,000 more than a parent in Florida for the exact same child. For families moving between states during or after a divorce, the choice of jurisdiction is not just a matter of convenience. It is a multi-six-figure financial decision. Furthermore, we must address the pro rata split of add-on expenses, which in 2026 often exceed the base child support amount. U.S. courts typically use a shared income model where base support covers only the essentials: food, basic clothing, and shelter. Everything else is categorized as an add-on. Imagine if the children are enrolled in a private Islamic school or a high-level competitive soccer academy. If the tuition and fees total $2,000 a month, the court will look at the parents' combined income. If Ryan earns 70% of the total income and Fatima earns 30%, Ryan is ordered to pay $1,400 a month for these extras on top of his base support. This includes unreimbursed medical expenses, which in 2026 can be substantial. If a child requires braces or long-term mental health counseling, and the insurance copays and deductibles reach $5,000 a year, that cost is split pro rata. For the higher-earning spouse, these add-ons create a variable and often unpredictable monthly liability that can prevent any meaningful personal wealth accumulation. To protect against the erosion of this support, 2026 divorce decrees are increasingly incorporating cost of living adjustments or COLAs. Because of the persistent inflation rate seen over the last few years, a fixed dollar amount for child support set in 2026 will have significantly less purchasing power by 2030. Modern courts are now building in automatic escalators. Every 1 or 2 years, the support amount is recalculated based on the Consumer Price Index. For the payer, this means their financial obligation increases automatically, even if their own salary remains stagnant. This creates an economic squeeze where the cost of the divorce grows every year, regardless of the payer's actual financial performance. It is a mandatory upward trajectory of expense that must be accounted for in any long-term budget. There is also the intersection of these civil mandates with Islamic financial principles, particularly regarding the use of interest-bearing accounts for these funds. If a U.S. judge orders Ryan to maintain the 529 plan or a specific educational trust, those vehicles are almost always invested in the stock market or interest-yielding bonds. For a parent seeking a Sharia-compliant financial life, this creates a direct conflict between a court order and religious conscience. In 2026, savvy legal teams are increasingly negotiating for the use of Sharia-compliant educational savings vehicles or halal investment portfolios to satisfy these court-mandated obligations. However, this requires a detailed, step-by-step presentation to the judge to prove that these alternative vehicles provide a comparable rate of return and security for the child's future. We must also examine the life insurance requirement as a form of security. In almost every high-stakes U.S. divorce, the parent paying support is ordered to maintain a life insurance policy with the other parent or a trust named as the beneficiary. The face value of this policy must be sufficient to cover the total remaining child support and college obligations if the payer were to die. For a healthy 40-year-old father in 2026, maintaining a $2 million term life policy might be affordable, but for someone with pre-existing health conditions or an older parent, the premiums can become a significant monthly drain. This is another hidden cost of divorce that is rarely discussed in community circles, but is a standard requirement in the American legal system to ensure that the state does not end up bearing the cost of the children's upbringing. The economic reality of being a parent in 2026 is that your children represent a long-term, court-enforced financial commitment that transcends the marriage itself. The state views the child's right to support as an entitlement that the parents cannot even contract away. You cannot simply agree to zero child support in your NICA or your civil settlement. The judge has the final say and will almost always follow the state-mandated guidelines to protect the child's best interests. This means that even if both parties want to follow a specific religious model of support, the civil court's math will always take precedence. As we look at these mounting obligations, from the 529 trap to the pro rata add-ons and the inflation escalators, a vital question remains. How do you manage the actual mechanics of this split without losing everything to the process? What happens when one spouse begins to move assets or lower their income specifically to avoid these formulas? And how does the 2026 landscape of remote work and international relocation complicate the enforcement of these payments? In the next part, we are going to dive into the world of asset dissipation and the legal tools used to freeze accounts before the first hearing even begins. We will explore the economic consequences of moving money to avoid child support, and why the IRS and the state enforcement agencies are now sharing data in ways that make it nearly impossible to hide income. We will also reveal the specific financial strategies used to defend against an unfair imputation of income, and how to prove your true cost of living in an economy that is changing faster than the law can keep up with. The moment a divorce petition is filed in a U.S. court in 2026, a legal mechanism known as an automatic temporary restraining order, or ATRO, typically goes into effect. This is not a restraining order in the sense of physical protection, it is a financial freeze. It prohibits either spouse from selling, transferring, encumbering, or concealing any marital property without the written consent of the other or a specific court order. For many in the American Muslim community who are accustomed to managing their finances with a high degree of privacy or through informal family networks, this sudden loss of control can be a massive shock. The law essentially seizes the steering wheel of your financial life to ensure that the status quo is maintained until a final judgment can be reached. Imagine a case study involving a character named Omar, a high-earning physician in Michigan in the year 2026. Sensing that his marriage to Nora is failing, Omar decides to proactively protect his wealth by transferring $200,000 to his brother's business account in Dubai, labeling it as a family loan repayment. He also spends $50,000 on a high-end luxury watch collection, thinking he can easily liquidate these items after the divorce is finalized. Omar believes that by moving these assets before the official filing, they will be invisible to the court. In a 2026 deep dive forensic audit, this is a textbook example of asset dissipation. Once Nora files for divorce, her legal team will initiate a step-by-step discovery process, subpoenaing Omar's bank records for the last 5 years. The forensic accountant will immediately flag the $200,000 outbound wire transfer. Under the economic waste doctrine, if Omar cannot prove that this was a legitimate, pre-existing debt with a written contract and a history of regular payments, the court will treat that money as if it still exists in Omar's bank account. If the total marital assets are determined to be $1 million, the judge will credit that $200,000 toward Omar's share. This means Omar has effectively spent 40% of his inheritance before the case even concludes. Historically, the potential outcomes for this kind of behavior include the court awarding the other spouse a larger percentage of the remaining liquid assets to compensate for the wasted funds. By 2026, the integration between the IRS, state child support enforcement agencies, and private financial institutions has reached a level of transparency that makes hiding assets nearly impossible. The financial institution data match system now operates in near real time across state lines. If a court issues a freeze order, the state can automatically flag any large outbound transfers or the opening of new accounts in the name of either spouse. Moving money to avoid support is no longer a matter of simple paperwork. It is a battle against a centralized digital grid. Historical trends show that those who attempt to starve their spouse financially by hiding income often end up paying significantly more in legal fees and court-ordered sanctions than they would have in a standard, transparent settlement. Now let us look at the other side of the economic battlefield, defending against an unfair imputation of income. In the volatile 2026 economy, sudden job loss or industry shifts are constant threats. Imagine a character named Sarah, who was a senior marketing executive earning $250,000. Due to a major AI-driven restructuring in her sector, her position was eliminated. She eventually takes a lower-paying role at $90,000, while continuing to look for a new executive position. Her ex-husband's legal team argues to the judge that Sarah is intentionally underemployed to either reduce her child support obligations or increase her claim for spousal maintenance. To defend against this, Sarah must follow a meticulous step-by-step procedure to prove her good faith efforts to maintain her former income level. She must maintain a comprehensive log of every job application submitted, every recruiter contacted, and every rejection letter received. In 2026, a vocational evaluation is the standard tool for this defense. Sarah hires a vocational expert who testifies in court, providing data on the current state of the marketing industry. The expert proves that there has been a 40% reduction in executive-level roles, and that Sarah's current $90,000 salary is actually the market rate for her skills in the current year. Without this expert testimony and a paper trail of effort, the court might impute her at her old salary, forcing her to pay support based on money she literally does not earn. Proving your true cost of living is equally essential for a fair economic outcome in an era of high 2026 inflation. U.S. courts require a document called a financial affidavit or a statement of net worth. Many people fill this out with rough estimates, which is a significant economic mistake. In a deep dive masterclass of divorce finance, we look at the lifestyle analysis. This involves a forensic accountant taking years of digital transaction data, credit cards, bank statements, and even digital wallet histories, and categorizing every penny spent during the marriage. If you can prove through this analysis that it actually costs $15,000 a month to maintain the marital standard of living, including costs for religious school tuition, zakat commitments, and specific dietary requirements, the court is far more likely to award a support amount that reflects that reality. If you fail to provide this data, the judge will default to a generic state-calculated needs table. In 2026, these tables often fail to account for the actual costs of living in high-stakes areas like Northern Virginia or Southern California. This can result in a support order that covers less than half of your actual monthly expenses, leading to a rapid depletion of your share of the marital assets just to survive the first year of separation. Consider the lifestyle inflation trap. Imagine if a couple lived a life far beyond their reported tax income, perhaps relying on cash from a side business or significant gifts from extended family. In a 2026 divorce, this lifestyle becomes the primary evidence. If Nora can prove through social media records, travel history, and household expenses that their monthly outgoings were $20,000, while Omar only reported $10,000 in income on his tax return, the judge will conclude that Omar has undisclosed income. The court will then impute income to Omar based on the lifestyle he actually lived. This creates a dangerous intersection where the pursuit of a higher divorce settlement can lead to a secondary investigation by tax authorities. The potential outcomes for non-compliance in 2026 are severe and go beyond mere fines. If a spouse is caught intentionally concealing assets, the court can order attorney fee shifting, making the dishonest party pay for both sets of lawyers. In extreme case studies, judges have issued contempt of court orders that lead to the suspension of professional medical, legal, or driver's licenses until the financial disclosure is made. The economic cost of being caught in a financial lie is now so high that full disclosure is the only viable strategy to protect your long-term wealth. Every financial decision made in the months leading up to a divorce filing is scrutinized. The buy and hold strategy for stocks, the timing of a bonus, and even the regular monthly support you send to family members overseas are all viewed through the lens of marital versus separate property. In 2026, the law does not just look at the balance in your account today. It looks at the path that money took to get there. But what happens when the assets aren't just hidden? What if they have been spent on things that the court deems completely inappropriate? What happens when one spouse has spent marital funds on a secret lifestyle, a gambling addiction, or has made massive donations to a religious organization that the other spouse never agreed to? How do you recover money that is no longer in the bank? In the next part, we are going to dive into the high-conflict world of dissipation claims and marital torts. We will look at the legal tools used to claw back money spent on non-marital activities, and the specific economic impact of domestic misconduct on the final split. We will reveal the 50-50 myth and explain why, in many U.S. states, a bad actor can end up losing significantly more than half of everything they own. The concept of no-fault divorce, which is the standard across nearly every jurisdiction in the United States in 2026, often leads people to believe that their conduct during the marriage is irrelevant to the final financial split. There is a common misconception that because a judge will not listen to the details of why a marriage ended, they also will not care how the money was spent leading up to that end. This is what we call the 50-50 myth. While the grounds for divorce may be neutral, the distribution of assets is governed by the principle of equity, and in the American legal system, equity is fundamentally tied to financial conduct. If one spouse has engaged in what the law calls the dissipation of marital assets, the 50-50 split is the first thing to go out the window. Dissipation or economic waste occurs when one spouse uses marital funds for a purpose entirely unrelated to the marriage at a time when the marriage is undergoing an irreconcilable breakdown. In 2026, the digital paper trail makes proving dissipation easier and more precise than at any point in legal history. Imagine a case study involving a character named Thomas, a corporate executive in Illinois. Throughout the final 2 years of his marriage to Sarah, Thomas maintained a secret second life. He utilized joint credit cards and a shared home equity line of credit to fund luxury travel, high-end jewelry purchases, and expensive dinners for a non-marital partner. He believed that since Illinois is an equitable distribution state, the court would simply look at the remaining balance in their accounts and divide it. However, during the discovery phase in 2026, Sarah's legal team uses AI-driven forensic software to categorize every transaction made by Thomas over the preceding 24 months. The software flags $300,000 in expenditures that provided no benefit to the marital unit. In the eyes of a U.S. judge, that $300,000 still exists on the balance sheet. This is the clawback mechanism. The court performs a step-by-step mathematical adjustment. If the current marital estate is valued at $700,000, the judge adds the $300,000 of dissipated funds back into the pot, creating a constructive estate of $1 million. Instead of Sarah and Thomas each receiving $350,000 from the remaining cash, the judge awards Sarah $500,000, her full 50% share of the constructive estate. Thomas is left with the remaining $200,000 and the jewelry and memories he already spent the rest on. In this potential outcome, Thomas has effectively lost 60% of the liquid assets he thought he would retain. This principle of economic justice extends into the sensitive territory of religious and family contributions. In many American Muslim households, it is common to send significant funds to extended family overseas, or to make large donations to religious institutions. Historically, if both spouses agreed to these transfers, they are considered marital expenses. But imagine a scenario where a spouse, let us call her Zainab, begins making large, undisclosed transfers to a family business in her home country, or to a specific religious foundation without her husband's knowledge, specifically as the marriage begins to sour. In 2026, a U.S. court may categorize these transfers as a unilateral depletion of the marital estate. The step-by-step defense against a dissipation claim regarding religious giving requires proving a consistent historical trend. If Zainab can show that the couple has traditionally given 10% of their income to that specific organization for a decade, the court will likely view the 2026 payments as a continuation of the status quo. But if the giving suddenly spiked or the destination of the funds changed as the divorce became imminent, the court will likely order an offset. The economic lesson here is that transparency is not just a religious virtue. It is a legal shield. In the American system, your right to be charitable ends where your spouse's right to their share of the marital property begins. We must also analyze the rising impact of marital torts in 2026. A marital tort is a civil lawsuit filed by one spouse against the other within the divorce proceeding for damages resulting from misconduct such as physical assault, intentional infliction of emotional distress, or even the fraudulent concealment of a financial condition. While the divorce decree handles the division of the 401k and the house, a marital tort judgment provides a specific dollar amount as compensation for harm. Imagine a case study involving a character named Michael who engaged in a pattern of financial abuse, preventing his wife, Sophia, from accessing funds for basic needs and sabotaging her career opportunities. In 2026, Sophia's attorney files a claim for the intentional infliction of emotional distress alongside the divorce petition. If Sophia wins a judgment for $200,000, that judgment acts as a powerful economic lever. If Michael was supposed to receive $500,000 from the sale of the family home, Sophia's legal team can place a lien on those funds. Michael walks away with $300,000, while Sophia receives $700,000. This is how a bad actor in a no-fault state can end up losing significantly more than half of everything they own. The financial misconduct creates a debt that must be paid out of the offender's share of the assets. Furthermore, we are seeing a trend in 2026 where courts are increasingly willing to look at the economic impact of domestic violence. While California or Texas might not award more alimony because a spouse was unfaithful, they will absolutely shift the distribution of assets if one spouse's violence reduced the other spouse's ability to earn a living. If a husband's actions cause the wife to lose her job or suffer long-term health consequences that require expensive treatment, the court may award her a 60 or 70% share of the marital estate to ensure her future financial security. This is not viewed as a punishment for the violence, but as a mandatory rebalancing of the economic scales to account for the victim's diminished earning capacity. The 50-50 myth also crumbles when we look at the costs of litigating these claims. In 2026, if a spouse is forced to spend $50,000 in legal and forensic fees just to uncover hidden assets or prove dissipation, the court has the authority to order the dishonest spouse to reimburse those fees. This is known as fee shifting. If you are caught hiding $100,000, you might not only lose that $100,000 but also be ordered to pay $50,000 for your spouse's lawyer and $30,000 for the forensic auditor. The economic math of dishonesty in a 2026 divorce is almost always a losing proposition. Every bank transfer, every hidden account, and every unilateral financial decision is a potential landmine. The American legal system is designed to protect the integrity of the marital partnership's balance sheet. When that partnership is breached through waste, secrecy, or abuse, the law provides a robust set of tools to claw back that value and redistribute it to the innocent party. The 2026 landscape is one of total financial accountability, where your digital footprint serves as the ultimate witness to your economic conduct. As we reach this point in our deep dive masterclass, we have covered the Mahr, the taxes, the business valuations, the child support traps, and the high-tech world of asset tracing. You now understand how the U.S. civil court views every aspect of your financial life. But the most critical part of the journey is yet to come. How do you take all of this knowledge and turn it into a successful post-divorce life? How do you rebuild your credit, secure your retirement, and navigate the social and financial reset that comes after the final decree is signed? In the final part of this series, we are going to provide the ultimate roadmap to the financial reset. We will look at the step-by-step process of decoupling your credit score from your ex-spouse, the specific strategies for managing your new, single-income budget in a high-inflation 2026 economy, and the psychological shifts required to view your settlement not as a loss, but as a seed for your new future. We will also reveal the one document that every person needs to sign the day after their divorce is finalized to prevent their ex-spouse from accidentally inheriting their entire estate. The end of the marriage is just the beginning of your financial independence, and we are going to show you exactly how to claim it. The final signature on a divorce decree in 2026 is often mistaken for the finish line, but in the realm of high-stakes finance, it is actually the starting gun for your most critical phase, the financial reset. The decisions you make in the first 90 days following the dissolution of your marriage will dictate your economic trajectory for the next decade. We are now entering the final stage of our deep dive masterclass, focusing on the tactical execution of your independence. This is where we move from the defense of your assets to the active reconstruction of your wealth in a volatile, high-inflation American economy. The first and most immediate step in the roadmap to a financial reset is the total decoupling of your credit identity. In the United States, credit is the lifeblood of your economic mobility. If your credit score is compromised, your ability to secure a mortgage for a new home, lease a vehicle, or even obtain competitive insurance rates in 2026 will be severely hindered. Imagine a case study involving a character named Michael, a project manager in Chicago. Michael walked away from his divorce with a fair settlement, but he neglected to monitor his joint accounts. His ex-spouse, struggling with the transition to a single income, missed 2 payments on a credit card where Michael was still listed as a joint account holder. In just 60 days, Michael's credit score plummeted by 80 points. When he went to apply for a loan to start a small consulting business, he was hit with an interest rate 3% higher than the market average, a potential outcome that cost him tens of thousands of dollars over the life of the loan. To avoid this, you must follow a rigorous step-by-step decoupling process. First, you must obtain a comprehensive credit report from all 3 major bureaus: Equifax, Experian, and TransUnion. You must identify every single account that bears your name, including those where you are merely an authorized user. Step 2 is the formal closing or freezing of these accounts. You cannot simply cut up the cards. You must provide the financial institutions with a copy of the divorce decree, if necessary, to remove your liability. Step 3 is the establishment of new individual lines of credit. In the 2026 economy, banks are increasingly utilizing trended data, which looks at your payment history over time. Starting these new accounts immediately ensures that by the time you are ready to make a major purchase, you have a clean, independent history that reflects your new financial reality. Next, we must address the brutal reality of the single-income budget in an era of 2026 inflation. Imagine a character named Jennifer, who transitioned from a dual-income household of $200,000 to a single income of $90,000, plus child support. Jennifer's biggest risk is the lifestyle lag, the tendency to continue spending as if she still has the cushion of a second salary. In the first 12 months post-divorce, Jennifer must implement a zero-based budget. This means every single dollar of her income, including support payments and investment dividends, must be assigned a specific job before the month begins. Historical trends show that the most successful post-divorce reconstructions occur when individuals aggressively downsize their fixed costs immediately. For Jennifer, this might mean moving from a high-maintenance suburban home to a more efficient townhome, even if the settlement allowed her to keep the house. By reducing her fixed housing costs from 40% of her income to 25%, she creates a liquid buffer that protects her from the 2026 fluctuations in energy prices and grocery costs. Step by step, Jennifer must categorize her expenses into 3 tiers: non-negotiable survival costs, debt service, and wealth building. If the third tier, wealth building, is not receiving at least 15% of her gross income, her long-term financial survival is at risk. This leads us to the critical management of the settlement funds themselves, particularly those received through a Qualified Domestic Relations Order, or QDRO. One of the most common economic mistakes is treating a retirement transfer as a windfall. Imagine if Jennifer received $250,000 from her ex-husband's 401k. The temptation in 2026 is to use a portion of that to pay off immediate debts or to furnish a new home. However, as we discussed in earlier parts, the tax consequences of withdrawing those funds are catastrophic. Instead, the focus must be on the strategic reinvestment of that capital into Sharia-compliant, diversified portfolios. In 2026, with the rise of specialized Islamic fintech platforms in the US, it is easier than ever to roll these funds into a self-directed IRA that aligns with your values while capturing the growth of the broader market. The goal is to turn that static settlement into a dynamic engine of compound growth. But there is one specific economic danger that can undo all of your hard work, and it lies in your estate planning. This brings us to the one document that every person needs to sign the day after their divorce is finalized: the new beneficiary designation form. In many U.S. states, a divorce decree automatically revokes the ex-spouse status as a beneficiary in a will, but it does not always override the contract you have with your life insurance company or your 401k provider. Imagine a case study involving a man named David. David finalized his divorce in 2026 and lived a successful life for another year. He had a new partner and was planning a future. However, David never updated the beneficiary form on his $1 million employer-sponsored life insurance policy. When David passed away unexpectedly, the insurance company was legally obligated to pay the $1 million to his ex-wife, despite their divorce and despite his intent to leave it to his children and his new partner. To prevent this, the step-by-step post-divorce audit must include a total revision of your estate plan. You must draft a new will, update your healthcare proxy, and most importantly, log into every financial portal, from your bank to your brokerage to your crypto exchange, to update your transfer on death instructions. In the 2026 legal landscape, these digital designations often carry more weight than a physical will. This is the only way to ensure that your wealth remains within the family and serves the purposes you intend, rather than being diverted back to an ex-spouse due to a clerical oversight. Furthermore, we must look at the psychological shift required for long-term wealth building. You must stop viewing your settlement as a payout for past suffering and start viewing it as the seed for your generational legacy. In the 2026 economy, where social safety nets are increasingly strained, your personal balance sheet is your only true security. This means becoming a student of the markets, understanding the impact of federal interest rate changes on your specific debt, and potentially exploring new avenues of income, such as side hustles in the digital economy or real estate syndications. As we conclude this deep dive masterclass, It is important to remember that the economic aspects of an Islamic divorce in the USA are a unique blend of ancient values and modern legal rigor. You have navigated the complexities of the Mahr, survived the forensic scrutiny of your assets, and understood the traps of child support and earning capacity. The roadmap we have laid out is designed to take you from the chaos of litigation to the stability of independence. But the world of finance never stops moving. As you rebuild your life in 2026, you will face new challenges, from shifting tax laws to the rise of new asset classes that didn't exist when you first got married. How do you prepare for the next phase of your journey? How do you ensure that the wealth you have fought so hard to protect actually grows and stays within your control for the next 30 years? The end of your marriage was the closing of one chapter, but your financial story is just getting started. In our next series, we will transition from survival to mastery. We are going to explore the high net worth roadmap for the single professional. We will dive into advanced tax strategies for 2027, the secrets of protecting your assets from future litigation, and how to build a legacy that survives for 3 generations. Your financial independence is now in your hands. Are you ready to see how far you can actually go?